What's up? What's up? What's up? Yes, somebody said I'm working overtime. Boy, I told you we was gonna have a double header today, honey. Now I gotta get caught up on these shows I missed over this weekend. But we are here. Sweet Pea said she paid admission. That means she hit that like button. Did everybody else pay the admission? My mom said, come on in, hit that like button, take a seat. Now we have two stories to get through tonight. We were going to just do Tiffany Henyard, but child, these lawsuits against Diddy just keep coming. So we're gonna talk about this newest Diddy lawsuit. And then we are going to get into Tiffany Henyard, the super mayor of Dalton, Illinois. We're going to talk about her alleged boyfriend and his indictment. We know that the grand jury met on yesterday to review those financial documents that we talked about last week. As it relates to her, it does sound like they are trying to build a case based on the information they asked for. If you guys want to get that information, you go back to the video we did last week. I'll drop the link in the chat. But as of right now, we are going to talk about her alleged boyfriend, and we are going to talk about, thank you, Francois. Hey, how you doing, boo? But we're going to talk about this newest Diddy case. And again, shout out to Tracy for forwarding the case to me. And then we're going to get into Tiffany Henyard, because the information on Tiffany Henyard is a little more information there. I think the Diddy situation, child, it's gonna be what it's gonna be with this Diddy thing. But let's get into it, honey. Let's get into it. Diddy. And at this point, here's what I'm gonna say about the Diddy thing. At this point, I can't say what's real and what's not, what's true and what's not. Like, I believed Cassie's case from the word go. But we did see this Lil Rod situation. We have read through some other cases. So I wasn't there. And I'm not going to tell these people what did or did not happen. We're going to read through the information. And, we're going to let the judge decide from there. Okay? So let's get ready to get into it. Without further ado, we're going to jump right in. Y'all know how we do over here. I'm going to share the screen. We're going to read through the document. Y'all know I am nobody's lawyer. I didn't go to anybody's law school. Y'all know I have my law degree from, Matlock College by way of Law and Order University. And I do take my continuing classes down to the law offices of Hood and Ghetto. Okay? So what I know, I learned from those three places. So we're going to jump into it. Ain't nothing to it but to do it, y'all. Let's get into it, okay? So you guys it should be coming up on the screen now. Remember, I can't see the chat when I'm reading these documents. So if you say something, I pause periodically so I can come over and I can read the chat. Now, we've gone through these lawsuits so much, so y'all just want the meat and potatoes, okay? If y'all want the legal analysis breakdown, you're going to have to listen to a lawyer do it. Y'all just want the meat and potatoes. So, we've been doing so much of these, we can scroll through some of this stuff, okay? So we can scroll through. We know that the plaintiff's name is Crystal McKinney. She is filing a lawsuit against Sean Diddy. And then, of course, she's going to list all of his entities. All right. The date on this is it was filed on November. It was filed May the 21st. Okay. As of I think this may be an updated one, but this is May the 21st. So let's read through it. Plaintiff demands a trial by jury. You know that this is the nature of the action. And then, of course, they give us jurisdiction. They show us why the plaintiff is filing this lawsuit in the proper place, why this court has jurisdiction. So it goes through why, there's jurisdiction. Y'all don't care about none of that. Y'all just want to know what this lady is saying Diddy did, and y'all want the narrative behind it. So let's read through what this woman is alleging that Diddy did, and then we are going to read through the narrative, okay? Y'all know sometimes it gets redundant, so I will try to, if I feel like it's repeating, I'm going to try to jump through. Like I said, we're going to cover two things tonight, so I want us to get to the meat and potatoes, okay? Procedural requirement. So again, the New York City Victims of Gender Motivated Violence Protection Act. So that is what that is the procedural requirement. It goes on to explain what that is. It was created a look back window on March 1st of 2023, which runs for 2 years for survivors of gender motivated violence, allowing them to sue their abusers. So I think, don't quote me on this. Do not quote me on this. I think this is one of the cases that was, hey, Kenneth Boo. I think this is one of the cases that was filed before the deadline, but they didn't put all of the details, and they said, we're going to come back later. We're just trying to beat the deadline. Remember, there was that amnesty window that ended on November. I think in New York, it ended on the day after Thanksgiving, because remember, it was that question about whether it had to be filed before Thanksgiving or after Thanksgiving, since the courts weren't open on actual Thanksgiving Day. But remember, a lot of cases were filed right there at the last minute, and it basically said, we reserve the right to refile once we have new information. They were just trying to beat the deadline. So this sounds like, and don't quote me on this, y'all, because again, I ain't no attorney, but that's what this sounds like, since they are talking about the Violence Act. That is that amnesty. So that's what it sounds like to me. Again, don't quote me. It revives any claims against a party who commits, directs, enables, participates in, or conspires in the commission of a crime of violence motivated by gender, has a cause of action against such party in any court of competent jurisdiction. The appellate division has held that SA is an act of gender motivated violence, so it's covered. The above described conduct of defendant Combs, including but not limited to his SA of plaintiff in New York City, constitutes a crime of violence and a crime of violence motivated by gender against the plaintiff as defined by the New York City Gender Motivated Violence Act. Okay. Again, it talks about the defendants. P. Diddy, aka Puff Daddy or Diddy. In 1992, he founded Bad Boy Records. In 2008, he was the first male rapper to get a start. I don't know why we need this. Okay. It's just giving us his accolades, child. We don't care about all of that. All right. Upon information and belief, P. Diddy has a long history of committing physical and sexual violence against women and men, as documented in publicly available lawsuits and extensive media coverage. And then it talks about Cassie. And then it talks about all the other lawsuits that have been filed against him. Liza Gardner, that's the one involving Aaron Hall. Joy Dickerson-Neal said that Combs allegedly drugged her and essayed her. Jane Doe, which filed a lawsuit, which said that was the one with Harvey Pierre, that she said she was assaulted in the studio. And Rodney Jones, which is the Lil Rod lawsuit. So it's just listed all of his lawsuits. Okay. Then it's talking about Sean John. Okay. This is the part y'all want to hear. Factual allegations. Okay. The plaintiff begins her modeling career. At the age of 17, plaintiff won MTV's inaugural model mission on December 5th, of 1998, a televised modeling competition akin to Miss America, and was awarded a modeling contract with IMG. Shortly thereafter, the plaintiff's career took off. Plaintiff modeled for a Tommy Hilfiger jeans commercial. Plaintiff modeled for a Tommy Hilfiger jeans campaign. Plaintiff was also featured in Macy's catalogs, Elle, Cosmopolitan, and Mademoiselle. Plaintiff also made appearances on television and film programs such as MTV's Total Request Live, Fashionably Loud, True Life, and a movie with Joan Rivers. Furthermore, plaintiff had international modeling gigs in Germany and Australia. A fashion designer invites plaintiff to Men's Fashion Week to meet Combs. In 2003, when the plaintiff was 22 years old, a fashion designer, and they put in parentheses, the designer, invited plaintiff to attend a Men's Fashion Week event held at Cipriani downtown, located, and they tell you the address. At the time, plaintiff was engaged in modeling gigs in Miami, Florida, and flew to New York for the event. The designer told plaintiff he would be introducing her to Combs, which could advance her modeling career. The designer began to direct plaintiff's appearance as he sought to ensure Combs found her attractive. For instance, the designer instructed plaintiff to go to Elizabeth Arden to get a new root touch-up to ensure it was platinum blonde. The designer also scheduled a stylist to put in her hair extensions for the plaintiff. The designer then handpicked a black leather coat with a fur hood, a translucent chiffon beige V-cut shirt, fur-lined handbag, and jewel-encrusted jeans for plaintiff to wear to the event. Due to the traumatic events to occur later, plaintiff saved the unwashed clothing from that night in her closet, where they remain in a So everybody want to be Monica Lewinsky now? Everybody want to be Monica Lewinsky now? When they say this took place, 1998? No, 2003. Hold on. In 2003, you had it wrapped in plastic for 21 years? What up, man? Hey, boo. All right, we're going to keep reading. I'm sorry, I had to take a pause on that one, but we're going to keep reading. Okay. Where it remains in a plastic wrap. Combs makes promises of career advancement. Soon thereafter, plaintiff took a car to Cipriani downtown where the designer was dining with Combs and other guests. Plaintiff felt little control over the events as she was directed to do and put on display for the others in attendance. Plaintiff felt little control over the events as she was directed what to do and put on display for the others in attendance. For instance, plaintiff sat at an empty seat next to the designer, but he insisted that she sit down directly across from Combs instead. Once again, Combs made a very public display of coming on to the plaintiff in a sexually suggestive manner, which continued throughout the dinner. For others to hear, Combs bestowed compliments on plaintiff by stating, for example, that she was beautiful and that her eyes were gorgeous. Later, and at a more intimate volume, Combs told plaintiff was going to make it big one day as a model. Combs went on to tell the plaintiff that he had the power in the industry and was going to help advance her career. Combs provided plaintiff with his phone number as a gesture of good faith in his promises to help her. Throughout her interaction, Combs was flirtatious, bordering on leering as he leaned across the table towards her. Combs also plied plaintiff with alcohol throughout the dinner as he repeatedly refilled her glass with wine. After the meal ended, Combs told plaintiff that he wanted to get to know her better. Combs asked plaintiff to call him a bit later. Plaintiff felt confused, but hopeful that Combs would fulfill his promises to help her career. You wasn't confused. You were not confused. Later that night, Combs requested plaintiff come see his studio located, and it gives the address. Plaintiff felt reassured that she would be with others at the studio rather than alone in a personal residence. When plaintiff arrived, she found that Combs had several other men seated together. She found that they were passing around a bottle of Hennessy and joints. After the plaintiff sat down, one of Combs' associates asked her, "Do you smoke weed?" To which she responded affirmatively. Combs' associate replied, "You never had weed like this before." Plaintiff later came to understand that Combs had laced the joint with a narcotic or other intoxicating substance. Combs passed her the joint, and the plaintiff took a hit, which felt very powerful. Although plaintiff insisted she had enough after that, Combs pressured her to inhale more alcohol and marijuana by telling her that she was acting too uptight. Plaintiff felt as if she were floating. Yeah, that's about right. Seeing plaintiff was very intoxicated, Combs demanded plaintiff follow him, and he physically led the plaintiff to the bathroom. In the bathroom, Combs forced himself on the plaintiff and began kissing her without consent. Combs then shoved her head, down to his crotch before commanding her to suck it. Plaintiff refused, but Combs pushed her head down onto his phallus and forced her to perform oral sex on him. As she was being assaulted, plaintiff felt panicked and physically sick. Afterwards, Combs led plaintiff back into the studio. Upon standing and walking, plaintiff felt more and more woozy and then lost consciousness. Plaintiff awakened in shock to find herself in a taxi cab heading back to the designer's apartment. As her consciousness returned, plaintiff realized she had been sexually assaulted by Combs. Plaintiff felt humiliated and traumatized and without recourse. All right, let me see what y'all saying. What Mem say? Diddy probably needs penicillin weekly. He nasty. Yeah, that's just nasty. Thank you for the super chat, boo. That's just nasty. That's just nasty. Now he's on a regimen of antibiotics. I was gonna say regime. Child, I'm here about 14 minutes behind. You good? Yeah, that's disgusting, you guys. That's so disgusting. And again, I wasn't there. I can't say what did or did not happen, but I think if we have read through all of these lawsuits against Diddy, and there are some things that are just consistent. I'm not saying that makes this story true. But there are some things that are just consistent. All right, let's keep reading. The Combs' assault has caused the plaintiff lifelong harm. Following the assault, plaintiff's modeling opportunities quickly began to dwindle and even evaporated entirely. Upon information and belief, Combs had plaintiff blackballed in the industry and utilized his significant influence to impede the plaintiff's career growth. Plaintiff became severely depressed as she began to blame herself for the assault and for sabotaging her own career. The assault led the plaintiff into a tailspin of anxiety and depression. On or about 2004, the plaintiff attempted to unalive herself and was hospitalized. Everywhere plaintiff looked, she was reminded of Combs' assault, as Combs was an inescapable presence in music, television, and film. In the ensuing years, plaintiff has also experienced alcohol and drug addiction as she attempted to cope with the emotional trauma of being assaulted. Plaintiff has also experienced intimacy issues as she struggles to maintain emotional and sexual relationships with men. Plaintiff was married for approximately 2006 to 2010. However, her marriage fell apart as she had a mental breakdown precipitated by memories of the assault. Combs' assault has altered the trajectory of the plaintiff's career, denying her a successful and lucrative career in the modeling and film industry. To this day, plaintiff experiences bouts of depression, anxiety, and body image issues. Feelings of worthlessness and intimacy issues because of Combs' assault. Plaintiff is a woman of faith, and when she saw news coverage of the lawsuits from Miss Cassie Ventura, Miss Dickerson Neal, and others, she knew she had a moral obligation to speak up. Plaintiff prayed to God before bringing this lawsuit, as she feared further violence and or retaliation from dependent Combs, but ultimately decided she needed to speak her truth. Excuse me, y'all. Plaintiff seeks justice for herself and any of Combs' other victims. So let me come back to the chat. Now listen, again, I'm not gonna sit here and say what did or did not happen, but y'all know we're gonna be critical thinkers. We're going to be critical thinkers over here, okay? I'm not saying that this did or did not happen. However, I have some questions. So question number one, why would she be blackballed if she did what he wanted her to do? Wouldn't it be the other way around? I'm not saying that makes sense. I'm just saying that's how my brain is thinking. I'm saying that's what my brain's thinking, right? Wouldn't she have gotten opportunities instead of the opportunities going away? I don't know. That don't mean, listen, predators don't make sense. So I'm not saying that makes him not. I'm not saying that means her case isn't true. Please understand that. Y'all know we believe victims over here until I have a reason not to. So I'm not saying this didn't happen. I just have questions. Right. I believe that. And I believe that. Listen, I told y'all this. Listen, what if y'all go back? I should have clipped it. We can go back and the video I did when we went over Cassie's lawsuit. I said it then, and I will continue to say it. There are going to be more and more people that are going to be empowered to come forward if, in fact, he is a predator. If, in fact, this is a pattern of behavior, and Cassie was not the only person, which I do believe that there are other people that's my opinion, that may have cause of action. Let me say it that way. I'm going to say this. I believe that the floodgates we're opening up. I told y'all that. I told y'all that back in November. So I believe that, listen, we know that there's no timeline for victims. We know there's no rhyme or reason for victims. We know that there are some victims who never speak up. And even though, I did my little pause and I looked to the side when we talked about that 20 years, there are people who hold on to these things for years and years and years and years. So her still having the evidence, honestly, is not it's not ridiculous. You know what I'm saying? Honestly, it's not ridiculous. But we're going to have the conversation because that's what we're here to do. We're going to talk about it. My other question is, I lost it. I forgot what my other question was. Damn. I didn't want to pause in the middle of that last part of the story. But I do think that other people coming forward has given her the courage to speak. I do. Especially after what happened this weekend with the video dropping and it giving even more validity to Cassie's story. You know what I mean? So again, I don't want anybody to think that I'm just asking as I'm reading through these are questions that are popping up in my head as I'm reading, right? All right. So now we get into the cause of action, which is basically, what are they asking for? What are they asking for? Or what is she asking for? Excuse me. And remember, and please don't nobody in my chat say, why is she asking for money? Because that is her only recourse. Okay. It is a civil lawsuit. And in a civil lawsuit, that is the only recourse. That's it. Now, if she did file this under the amnesty, then it's still civil unless the DA picks up the case. And in her case, if there is that artifact that has DNA, but I doubt that the DA let me not say that, because if they are building a case, they might, child. Who knows, child? Who knows? But before I start reading this, I don't want nobody in the chat talking about why they asking for money, because that's all they can ask for. Okay, all right. Plaintiff reiterates, and realleges each and every allegation made in the above paragraph of this complaint, as if more fully set forth herein at length. The New York City Gender Motivated Violence Act revives any claims against a party who commits, directs, enables, participates in, or conspires in the commission of a crime of violence motivated by gender, has a cause of action against each party or any court of competent jurisdiction. Excuse me. Honestly, it's really just repeating what we already read up top. Hold on, y'all. The appellate division has held that SA is an act of gender-motivated violence under the law. So this is really repeating what we already read, child. Defendant Combs coerced the plaintiff to engage in sexual conduct and or sexual intercourse, despite the fact that she was rendered incapable of consenting due to intoxication. Defendant Combs gave plaintiff several drinks throughout the night and a laced blunt. Thus, he knew or should have known that the plaintiff was incapable of consenting to sexual conduct and or sexual conduct. Defendant's actions presented a serious risk of physical injury to plaintiff's person, regardless of whether or not these acts resulted in criminal charges, prosecution, or conviction. As a direct and proximate result of the aforementioned crime of violence and gender-motivated violence, plaintiff has sustained and will continue to sustain monetary damages, physical injury, pain and suffering, and serious psychological and emotional distress, entitling him to an award of compensatory and punitive damages, injunctive and declaratory relief, Attorneys' fees and costs and other remedies this court may deem appropriate damages as set forth, and it gives the statute. Furthermore, defendants Bad Boys, Sean John Clothing, LLC, and Universal Music Group, Incorporated, enabled defendant Combs' commission of the crimes of violence motivated by gender and thus are liable under New York City Victims of Gender Motivated Protection Act. Okay, it says that the defendants failed to, among other things, protect the plaintiff from a known danger, have sufficient policies and procedures in place to prevent sexual assault, properly implement policies and procedures to prevent SA, take reasonable measures to ensure that policies to prevent SA were working, train their employees on identifying SA and appropriate workplace behaviors, protect their employees from SA, and adhere to the applicable standard of care. Defendants failed to timely and properly educate, train, supervise, and or monitor their agents or employees regarding policies and procedures that should be followed when SA of a child is suspected or observed. Prior to Combs essaying the plaintiff, all of the Bad Boy, Sean John, Universal Music knew or should have known that Combs was not fit to be in a position of authority. Defendants by and through their agents, servants, and or employees became aware or should have become aware of Combs' propensity to commit SA and the risk to plaintiff's safety. At the very least, defendants knew or should have known that they did not have sufficient information about whether or not their leaders, managers, and people were safe to be in positions of power. Defendants knew or should have known that Combs proposed a risk of SA. Now, I don't know how they were supposed to know that. Defendants knew or should have, defendants failed to properly survive Combs and protect plaintiff from a known danger and therefore enable Combs as aides of the plaintiff. The defendants deemed Combs was fit to be in a position of authority and that any previous suitability problems Combs had were fixed and cured, and that Combs would not commit acts of SA on that of Combs would not injure others. Moreover, defendants enabled the SA of plaintiffs by actively maintaining and employing Combs in a position of power and authority through which Combs had control over people, including the plaintiff. As a direct and proximate result of the aforementioned crime of violence and gender-motivated violence, plaintiff has sustained and will continue to sustain monetary damages, physical injury, pain and suffering, and serious psychological and emotional distress, entitling her to an award of compensatory and punitive damages, injunctive and declaratory relief, attorney's fees and costs, and other remedies of this court may deem appropriate damages. Plaintiff demands a trial by jury of all issues. So here's what the plaintiff wants. Declaring the defendant Combs engaged in unlawful practices prohibited by the New York City Victims of Gender Motivated Violence Protection Act, and that Combs drugged and sexually assaulted the plaintiff. So she wants him to admit that he did it. Declaring the plaintiffs that they enabled the defendant's behavior, the commission of crimes of violence motivated by gender. Awarding the plaintiff compensatory damages for mental and emotional injury, distress, pain, and suffering, and injury to her reputation in an amount to be proven. They want awarding the plaintiff damages for the defendant's breach of contract. I didn't see where they established the contract. I see what he said he would help her, but I didn't see no contract. But okay, I ain't no attorney. Awarding of punitive damages, awarding plaintiff's attorney's fees, costs, and expenses incurred by the prosecution of the action, and awarding the plaintiff such other and further relief as the court may deem equitable, just, and proper. And then it's signed by all of the people. Now, I'm not being funny. Did I miss it? When was there a contract? I mean, I know that the designer was introducing, that's a verbal contract. Okay. All right. Okay. I smell Gloria Allred in a class action lawsuit. Child, please not Gloria Allred. Please not Gloria Allred. I mean, I know for a verbal contract, there has to be a offer and an acceptance of the offer and a meeting of the mind. I didn't necessarily hear that, and not in that lawsuit. Now, maybe I missed it. Maybe when he said he would help her career. But what does that mean? That's not, what does that mean? Help your career. That could be so many different things. That doesn't, I don't think, because there has to be a meeting of the mind. So a meeting of the mind means I know exactly what you mean and you know exactly what, and I know, we know exactly what. So when he says, I'm going to help you with your career, what does that mean? Does that mean that I'm going to have you be a model for Sean John? Does that mean I'm going to call my friends in the industry and get you on the runway? Does that mean I'm going to get you print work? Does that mean I'm going to get you runway work? Does that mean that I'm going to make you the face of Sean John? Does that mean I'm going to call my friend Russell Simmons and make you the face of Baby Fat? Because this was in 2003. So when there's a verbal agreement, there has to be a meeting of the mind. Just saying I'm going to help your career, I don't know if that meets the bar. I don't know if that means, and again, I ain't no attorney, but I don't know if that meets the burden of proof to say there was a meeting of the minds. To say when somebody says, I'm going to help you with your career, that could mean so many different things. Does that mean I'm going to pass your resume on to a friend of mine? Does that mean I'm going to give you a job myself? Does that mean I'm going to help you rewrite your resume that will help you in your chances of getting a job? Does that mean I'm going to give you an internship that will help you beef up your resume? I don't know. And here's the thing. I'm not trying to make Diddy right. I'm just saying I didn't see it. But again, I didn't go to nobody's law school. So my understanding of meeting of the mind might not be right. You know. Gloria told Piers Morgan on his show this week that she is representing women who may file against Diddy. I knew it was only a matter of time before she was going to enter the chat, child. I knew it was only a matter of time before she was going to enter the group chat. Here she come. Here come Gloria. Like Santa Claus. Here come Gloria. Here come Gloria. So that is the newest lawsuit. Looks like it was updated on May the 21st. So that was literally yesterday. Or is that today? Today's the 21st, isn't it? Oh shoot, today is the 20th. So that was today. It was updated. I'm sorry, y'all. It was updated today. So that is the latest news. Of course, we'll keep you guys posted. As we continue to get more information. Y'all know that's what we do over here. That's what we do over here. Right, today. Thank you, Carol, child. Woo, today is the 21st. All right. Now, let's switch gears for a second. Let's cleanse our palates, you guys. Let's switch gears. Let's get on the plane. Let's fly from New York to Illinois. We're going to fly from New York to Illinois. We're going to get off the plane, get in our rental car, and drive down to Dalton. Okay, we got to drive down to Dalton Township. Now, for those of you who are new here, we've been following this Tiffany Henyard. Well, we haven't been following it. We are late to the game. Tiffany Henyard, this situation been going on for 2 years, child. So we're late. We're late to the group chat, okay? But we done came into the group chat a couple of weeks ago, and we've been trying to get caught up. So we talked about the grand jury and the subpoena that the grand jury sent out. The grand jury convened yesterday. There's going to be, listen, all that information they asked for is going to take time, okay? So I don't want anybody expecting an indictment or anything to come out of the grand jury anytime soon. I mean, I don't know how these things work. I ain't never sat on a grand jury, but with all that information they asked for, all those financial documents that they asked for that they're going to have to go through and all of that stuff, baby, it's going to be a minute. However, those indictments were very specific, and we've already talked about when the feds come knocking. When the feds come knocking. Now, last week, there was a board meeting where they did put a mayor pro temp in place. I'm assuming in anticipation that her days are numbered. I'm assuming that her days are numbered, okay? We talked about the lawsuit by the woman that's alleging she was assaulted on the trip to Las Vegas. We read about another woman who is suing the mayor and the township as it relates to harassment and false arrest and prosecution. We talked about the police officers getting all the overtime. Now, I do have an update. The guy that was named in the assault case against the former employee of Dalton, he has been fired. So he is no longer on the board. He has been fired. Okay. Carol said we need to get them likes up. It's 151 of y'all in here. I know we were here earlier. You know that the algorithm is, you know, that my notifications probably didn't go out to everybody. So some people are gonna catch this in the on the replay. But if you're here, if you could please hit that like button, I appreciate that so much. It's 152 people in here. If you guys could get us up to over 100 likes, that would be great. Again, remember, tips are not required, but they are accepted and appreciated. Thank you for the tip. Mims already hit me with a tip already, the super chat. So, you know, if y'all want to hit me with a tip, y'all can do that as well. All right. Now let's flip on over here. Let me read you. I have the article breaking down what this guy allegedly did, and then I have the actual lawsuit. So I'm going to try not to be redundant, but we're going to go through both because one is more of a narrative of what happened. And then, of course, we have the lawsuit. So, again, we're going to do both. So, screen. Can't wait for the feds to come knocking. I know that's right. I know that's right. Come on, share screen. All right, here we go. All right, so this is dated April the 16th, 2024. This is from justice.gov, I think is the website. Yeah, justice.gov. Senior administrator for Dalton, Illinois, and Thornton Township, Illinois, charged with federal court and bankruptcy fraud. Now, the first thing we're going to notice is that this man also had two jobs, very like the mayor, where she is she's the city commissioner and the mayor. She's the mayor of Dalton, and then she's the commissioner for the township of Thornton. So he too has two jobs, and that's going to become important when we look at the lawsuit, the indictment, okay, that he has these two jobs. So, all right, let's read through it. A senior administrator for both the village of Dalton and Thornton Township has been charged in federal court with engaging in a bankruptcy fraud scheme involving the making of false statements in his bankruptcy petition to conceal from creditors his assets and sources of income and a significant claim against him. An indictment returned Monday in the U.S. District Court of Chicago charges Keith Douglas Freeman of Orland Park with one count of bankruptcy fraud. The charge is punishable by a maximum sentence of 5 years in federal prison, and arraignment has not yet been scheduled. Now, he has been arraigned as of today, and I believe he pled not guilty. The indictment was announced by Morris Pascal, acting U.S. attorney for the Northern District of Illinois. And then they name all these people, child. We don't need to go through all these people. Valuable assistance was provided by the U.S. trustee program. The government is represented by assistant U.S. attorney. Okay, we don't need all that. The official noted that Freeman was indicted as part of an ongoing federal investigation. I think that's important. Ongoing federal investigation, which means that they're looking at more than just him. He was just dumb. Thank you, Carol. I'm glad to be a member of this tribe. You rock. Thank you. Thank you for the super chat, my love. Thank you so much. That's not her boyfriend? But I read that allegedly that's her boyfriend. Who her boyfriend, Miss Carter? Tell me who he is. Tell me who this man, who the boyfriend is. Okay. According to the indictment, Freeman on January the 3rd filed a Chapter 7 bankruptcy petition in the U.S. Bankruptcy Court in Chicago. The petition included a schedule and statement of financial affairs, a document in which the debtor is required to identify, among other things, all of his assets and sources of income, as well as any claims against him. The indictment alleges that Freeman made several materially false statements and omissions in the document, including knowingly underreporting income he derived from his employment as both the village administrator for Dalton and the municipality manager for Thornton Township, as well as fees he received from his private and consulting business. Freeman also allegedly concealed that the village of Robbins had filed a claim against him and related to approximately $90,000 that Freeman received in excess of his authorized salary while he was the village administrator for Robbins, a position he held for 2017 to 2021. So on top of all of this, they saying that they overpaid him and he took the money. Remember, he was also listed on those lists of documents that the grand jury wanted as it related to his employment and his financial documents as well. Freeman also furnished the Chapter 7 trustee with a purported copy of his 2002 income tax return, which represented the Freeman's total income from employment was $45,000. The indictment states that Freeman knew he had not filed an income tax return for that year and that his actual income, which included a $100,000 salary for the Dalton position alone, subsequently exceeded that amount. Okay, we're going to have to pause there. We're going to have to pause there. That's her side piece. I thought they said that was her alleged boyfriend, but I could have read wrong. I could have read wrong. Her alleged boyfriend works for the village, right, for a local nonprofit that's somehow connected to the village. I thought this was the same guy. I thought this was the same guy that they said ran her nonprofit. Did I get the names mixed up? Hold on, I'll look it up. Give me a second, because I don't want to put that on this man if that's not the right person. Hold on. Give me a second. And then we're going to cuss this man out because that's just stupid. That's just dumb. Okay, hold on. I don't want to be wrong. Freeman is just a fellow scammer, so that's not him. Okay, all right. Then my apologies. I'll change the title. Hold on. I will change the title because I do not want to lie on nobody. If he's just a fellow scammer, I'll change the title. Okay. All right. The boyfriend is Kamal Woods. You know what? Okay, Miss Carter, thank you. I'll change the title. I'll change the top aide. I'll change it as soon as we get off of here. Okay, sorry about that, y'all. Okay, Kamal Woods. You're right. That name does sound familiar now. Kamal Woods. All right, my bad, y'all. Anybody watching this in the replay, don't leave it. Listen, hey, if you are watching this in the replay, I'm changing the title and I'm correcting myself right here at the 46-minute, 21-second mark, okay? Kamal Woods is the alleged boyfriend. Freeman is just a top aide that is allegedly a scammer too, okay? My apologies. I got the names mixed up, child. My bad, y'all. But I will change the title. Don't leave it in my comments. What second email, Tracy? Hold on. About Diddy? The second Diddy email? Because that's the one we just read. Hold on. You talking about the second? If you talking about the second Diddy email, yeah, I got it. Yeah, the updated one that you sent at like 8:15. Yeah, thank you. Yeah, Freeman is now the information I'm reading is for Freeman, but Kamal Woods, I'm gonna have to go back and pull his information. My bad, y'all. My bad. Okay. But let's finish reading through this. This is for Freeman. But okay, but hello, sir. Hey, Mr. Freeman. What the hell made you think that the federal government did not know what you did and did not make? If you paid taxes, what made you think they was just gonna go by your word and say, "Oh well, I only made $40,000 last year when I really made $100,000"? And what made you think they didn't know that you didn't file taxes? Like, do you not think now you might have got away with something like that 50, 60 years ago before everything was online and it was paper and it took a long time for the agencies to talk to each other. They couldn't just shoot an email or put in a social security number. Everything is fucking linked up. Maybe 50, 60 years ago when they had to actually pull it and run it down and do the snail mail and put it in an envelope and run it back and forth to the different agencies, and somebody had to read it. And if somebody screwed up and wrote an 8 instead of a 7 for your social security number and you got away with it. Like, but what in the entire hell made you think that in 20 of the 23, you could just tell the government, "Oh, I only made $40,000 last year," and they wasn't going to know? What made you think you could file paperwork for tax, a tax lien, tax paperwork, and you never filed your taxes? What is wrong with y'all? Let's finish reading this thing, child. Let's finish reading this thing. It was further part of the scheme that on January the 30th of 2024, while testifying under oath at a meeting of creditors, Freeman falsely represented that he was not an employee of Dalton and that he did not receive payment from Dalton. The indictment states, the following month, Freeman allegedly caused his pay from Dalton to be directly deposited into a recently opened bank account that he had not disclosed to the creditors for Chapter 7. The public is reminded that an indictment is not evidence of guilt. The defendant is presumed innocent and entitled to a fair trial at which the government has the burden of proving guilt beyond a reasonable doubt. If convicted, the court must impose a reasonable sentence under federal statute and the advisory of U.S. sentencing guidelines. So, I'm sorry. Let me get this straight. You testified under oath in front of your creditors that you did not work for the township of Dalton, and you thought, and you, Mr. Freeman, thought that all you had to do was change the bank account in which your paycheck was deposited into. Sir, you are on the payroll, which means you filled out, what is it, a W? What is that thing when you first get an I-9? What is that thing you fill out when you first get a new job? You filled out paperwork. They filed that paperwork. They're taking taxes out of that paycheck. Just because you changed bank accounts and the money is being deposited into a different bank account, it doesn't mean that they don't know you're getting a paycheck. Y'all, he deserved to go to jail because he just dumb as hell. Like, if that's really how he was thinking, I-9, thank you, Carol, I-9. If this man really truly was thinking, what? Y'all. He can't be that dumb. Dumb or desperate? What y'all put in the chat? Was he that dumb or was he just that desperate? Because he can't be that dumb. Right? Listen, please put it in the chat. Was he that dumb or that desperate? I don't know. I don't know. But let's pull up the indictment. Oh, Lord. Let's pull up the indictment, child. Damn. Yeah, this man really changed bank accounts and thought they wasn't going to find the money. Oh, oh, Lord. Let's read the indictment, y'all. Excuse me. Defendant Keith Douglas Freeman resides in Orland Park, Illinois. Freeman generated income from various sources, including the following. From in or around January 2022 through in or around April of 2024, Freeman was the village administrator of the village of Dalton with an annual salary of approximately $100,000 from in or around March 2022. Though in or around April of 2024, Freeman was the municipality manager of Thornton Township with an annual salary of approximately $70,000. From in or around November 2017 through in or around April of 2021, Freeman was the village administrator of the village of Robbins with a salary by village ordinance, and from at least in or around December 21 through January 2022, received approximately $24,000 in consulting fees from a business located in Northfield, Illinois, that financed the lease, purchasing of firefighting and other equipment by municipalities and governmental organizations. Freeman was affiliated with multiple companies, including the following. Freeman was the sole owner of Government Staffing Advisors, Inc. Oh, that's one of the companies that's in the indictment. Y'all remember that? Government Staffing Advisors. I remember that because I remember thinking they named it. Okay. Anyway, that is one of the businesses that's in the indictment before the grand jury. Boy. Hold on. I'm reading. I came back to the chat. Let me see. What's up, House of Princess? $250 still indictments and Pacer, Diddy, Jay-Z. I don't know what you're talking about, OG Drew. What you talking about? 250 sealed indictments and Pacer. I don't know what you're talking about, OG Drew. You just dropped that in there. There's no context to it. I don't know what you're saying, baby. Paycheck earnings lead to eventually having the company government having to file tax. Right. All right. Let me finish reading the indictment. Let me go back to the indictment. Freeman was affiliated with multiple companies, including the following. Freeman was the sole owner. I just read that. Sorry. Freeman was an owner of Keith Freeman LLC, Doodads Novelty Store. Freeman was an officer of CBPI Inc. CBPI Doodads, a corporation owned by Freeman's spouse. Freeman had control and signature authority over multiple bank accounts, including the following. Freeman was the sole account holder and signature of a JP Morgan Chase account. Freeman was the sole account holder and signatory of Bank of Montreal. Freeman controlled and was the sole administrator for Coastal Community Bank account, an account opened in the name of Government Staffing Advisors. All right. Chapter 7 of Title 11 United States Code provides individuals who are unable to pay their debt with an opportunity to obtain a fresh financial start through the discharge of pre-existing debts. In order to initiate a Chapter 7 bankruptcy case, an individual known as the debtor was required to file a bankruptcy petition with the United States Bankruptcy Court. The filing of a Chapter 7 bankruptcy petition automatically stayed collection activity by creditors against the debtor. We talked about that with Tasha K. In addition to bankruptcy petition, a debtor was required to file certain documents with the United States Bankruptcy Court that detailed the debtor's financial condition, known as schedules, and a statement of financial affairs. With respect to the schedules, the debtor was required to disclose his current financial circumstance and sign a statement under penalty of perjury, and the schedules were true and correct before filing them with the United States Bankruptcy Court. The information the debtor was required to provide in the schedules included the following. Schedule A and B required the debtor to disclose deposits of monies in financial accounts. Schedule EF required the debtor to disclose unsecured creditors. Schedule I required the debtor to disclose both the debtor's employment and self-employment status, occupation, and monthly income. With respect to the financial affairs, the debtor was required to disclose his financial history including his employment, income from operations of business, and any other source in the year of filing and for the immediate 2 prior calendar years, and whether he was an officer of a corporation. As with the schedules, the debtor is required to sign a statement under penalty of perjury that the statement of financial affairs was true and correct before filing it with the United States Bankruptcy Court. Now, we talked about this when we talked about Teresa Giudice. Remember, we talked about how Teresa, when she filed bankruptcy, her trustee gave her 2 opportunities to amend the bankruptcy so that it wouldn't be held, it wouldn't be held against her, okay? This just stupid. This just stupid. Like, he is dumb. The United States trustee is responsible for ensuring the integrity of the bankruptcy system and for promoting compliance with the bankruptcy laws and rules applicable to bankruptcy proceedings. To this end, the United States trustee appointed and oversaw the activities of the trustee, who was responsible for administering individual Chapter 7 bankruptcy cases for the benefit of the debtors and creditors. Again, this goes back to what we said about the Teresa Giudice case. The information provided in schedules and the statement of financial affairs was material to a determination by the United States trustee, the Chapter 7 trustee and creditors, whether based on the doctor's income, the debtor had properly filed a Chapter 7 bankruptcy petition, whether the debtor had disclosed assets consistent with his income, and whether the United States trustee, Chapter 7 trustee, or creditors should object to the discharge of the debts or move to dismiss the bankruptcy case. A debtor was required to appear at a meeting of creditors known as a 341 meeting. Again, we talked about this when we went over the Tasha K case. Remember, we had this conversation. And to testify under oath concerning his financial affairs. Prior to the 341 meeting, a debtor was required to provide the Chapter 7 trustee with a copy of the debtor's federal income tax return filed with the Internal Revenue Service for the most recent tax year prior to the commencement of the case. Beginning on or around July 2023 and continuing until in or around April of 2024, the Chicago and Orland Park in the Northern District of Illinois, Eastern Division, and elsewhere. So it's just reiterating that the trustee was responsible for, hey, what's up, Peace? The trustee was responsible for getting the information, making sure the information was accurate, and then they would make a determination based on what was submitted, whether the debt should be dismissed or upheld. So he knew he was testifying under oath and under penalty of perjury. It was not a surprise. Keith Douglas Freeman, defendant herein, devised and intended to devise a scheme to defraud, and for the purpose of executing and concealing the scheme and attempting to do so, filed and caused to be filed documents in a bankruptcy case under Title 11 of the United States Code. It was part of the scheme that for purposes of fraudulently staying debt, collection actions, and fraudulently obtaining a discharge of his debts, Freeman attempted to and did defraud his creditors and the Chapter 7 trustee by taking steps to conceal his assets and sources of income prior to filing a bankruptcy petition, and by then filing a bankruptcy petition and making false statements and providing false documents during the course of the bankruptcy case that were designed and intended to, 1, conceal Freeman's actual financial circumstance and history, 2, conceal Freeman had disclosed assets consistent with his income, and 3, fraudulently prevent creditors and Chapter 7 trustee from determining whether Freeman had properly filed for Chapter 7 bankruptcy protection, and 4, fraudulently prevent creditors of the Chapter 7 trustee from objecting to the discharge of Freeman's debts or moving to dismiss the bankruptcy case. It is further part of the scheme that on or about July the 12th of 2023, Freeman created Government Staffing Advisors, Inc., and on or about July the 23rd, opened a bank account with Coastal Community Bank in the name of Government Staffing Advisors. It is further part of the scheme that beginning on or around July of 2023, for the purposes of concealing his income and personal financial transactions from his creditors, Freeman stopped using BMO account, and Freeman's name was transitioned his banking activity to Coastal Community Bank in the name of Government Staffing Advisors. It was further part of the scheme that on or about July the 3rd of 2024, Freeman filed a bankruptcy petition in the United States Bankruptcy Court for the Northern District of Illinois, thereby initiating a Chapter 7 bankruptcy case. So you thought that changing your bank account was going, boy, bye. It is further part of the scheme that on or about July the 3rd, Freeman filed in the Freeman bankruptcy case his schedules and a statement of financial affairs signed under penalty of perjury that contained materially false statements and material omissions. It was further part of the scheme that on or about July the 3rd of 2024, Freeman filed a Schedule A and B and the Freeman bankruptcy case, disclosing total assets of approximately $5,000. $5,000. That was your total asset. That's it. That's all. $5,000. The Schedule AB was false and fraudulent in that, in response to question 17, deposits of money which required Freeman to identify financial accounts, Freeman falsely represented that he had a single checking account at BMO Bank, when in truth, Freeman knew that he was then using the Coastal Community Bank account in the name of Government Staffing Advisors as a personal account, including depositing money into the account that he earned as municipality manager of Thornton Township. It is further part of the scheme that on or about July the 3rd, Freeman filed a Schedule EF in the Freeman bankruptcy case, disclosing total debts of $174,000 that was false and fraudulent, in that Freeman, knowing that the Village of Robbins had a claim against Freeman for unauthorized payments, did not list the Village of Robbins as an unsecured debtor, which deprived the Village Robbins of notice and the opportunity to timely participate in the bankruptcy case. Oh, boy. It was further part of the scheme that on or about July the 3rd of 2024, Freeman filed a Schedule I in the Freeman bankruptcy case that was false and fraudulent, in that Freeman falsely represented that his only employment was that of the municipality manager of Thornton Township, when he knew he was also the village. When he knew he was also the village administrator of the Village of Dalton. Y'all. 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 Freeman falsely represented that his monthly income was approximately $7,000, when he then knew that his monthly income was both the municipality manager of Thornton Township and the village administrator of the Village of Dalton, which is approximately $15,000. Sir, that is more than double. Sir, that is more than double. It was further part of the scheme that on or about January the 3rd of 2024, Freeman filed a Schedule J in the Freeman bankruptcy case that was false and fraudulent, in that defendant falsely represented that his net monthly income was $94,000. Hold on, wait a minute. I'm sorry. That his monthly income was, I'm sorry, my bad. I was adding, I don't know where I got all them zeros for. That man said he made $94 a month. I want to make sure I'm saying that right. $94.72. That's what he said. Let me read that again. The defendant falsely represented that his net monthly income was $94.72. $94.72. When defendant then knew that his net monthly income was substantially in excess of $94.72. Sir, you want to go to jail. You wanted to go to jail, right? You wanted to go. There's no way in the world that you thought this was going to work. You are either that dumb or that desperate. I'm going to go back to it. He's either that dumb or that desperate. Sir, $94.72. $94.72. Okay. Okay. Y'all, this just get worse and worse the more I read. It just get dumber and dumber. It's like the movie Dumber and Dumber. It just get dumber and dumber the more I read. It is further part of the scheme that on or about January the 3rd of 2024, Freeman filed a statement of financial affairs in the Freeman bankruptcy case that was fraudulent in that Freeman falsely represented that for the calendar year of 2022, his gross income was $45,000, when he then knew that his gross income from his employment as both the municipality manager of Thornton Township and the village administrator of Village of Dalton, combined with consulting fees from Company A, was approximately $140,000. Again, sir, $100,000 more than what you're reporting. $100,000 more than what you are reporting. Freeman falsely represented that for the calendar year of 2023, his gross income was $99,000, when in fact he knew that his gross income from his employment as both jobs was approximately $195,000. Freeman falsely represented that the only business that he owned was Keith Freeman LLC, when he then knew that he also owned government staffing advisors. So you started a whole nother company and opened up a bank account. You have a whole bank account with the name Government Staffing Advisors. Sir, a whole bank account. It was further part of the scheme that Freeman attempted to and did conceal material facts from his creditors and the Chapter 7 trustee, including but not limited to the fact that as of the filing of the Freeman bankruptcy case, he was the village administrator of the Village of Dalton. He earned approximately $100,000 in annual income from this position as the village administrator of the Village of Dalton, was the owner of Government Staffing Advisors, controlled a bank account at Coastal Community Bank with Government Staffing Advisors on the name, to which he deposited his income and which account Freeman used as his personal bank account, was an officer of CBPI Inc., a corporation owned by his spouse, had within the 2 years prior received income in the form of consulting fees from Company A. While employed as the village administrator of the Village of Robbins, had received approximately $90,000 in excess of his authorized salary. So on top of all of that, you allegedly was stealing money. And that the Village of Robbins had a claim against him related to those funds. It was further part of the scheme that on or about January 30th of 2024, Freeman caused to be submitted to the Chapter 7 trustee a purported copy of his 2022 Form 1040 individual income tax return signed under penalty of perjury, when in truth, Freeman had not filed taxes in 2022. Sir, you falsified your tax papers. So let me get this straight. Let me just make sure I got this straight. You did not file federal taxes. Federal taxes. But in federal bankruptcy court, you presented falsified federal paperwork of the alleged federal taxes that you did not file. And you didn't think nobody was going to make the connection. You didn't think that the federal bankruptcy court and the IRS, you didn't think they was going to talk to each other? You didn't. Okay. We almost done, y'all. We almost done. It is further part of the scheme that the phony 2022 Form 1040 individual income tax return Freeman provided to Chapter 7 trustee falsely represented that Freeman's total income from employment was $45,000 when Freeman knew that his income from employment in 2022 substantially exceeded that amount. It is further part of the scheme that on or about July the 30th of 2024, while testifying under oath at a 341 meeting, Freeman falsely represented that he was not an employee of the Village of Dalton and that he did not get paid by Dalton. It was further part of the scheme that on or about February the 23rd of 2024, 4 days before his next scheduled 341 meeting, on February the 27th, Freeman caused his pay from the Village of Dalton to be directly deposited into the Coastal Community Bank account. So you really thought they wasn't going to know. Which that account had not been disclosed to the creditors of the Chapter 7 trustee. It was further part of the scheme that Freeman did misrepresent, conceal, and hide, and caused to be misrepresented, concealed, and hidden acts done in furtherance of the scheme and the purposes of these acts. And then it just goes on or about January the 3rd at a Chicago in the Northern District of Illinois. Defendant Keith Douglas Freeman herein for the purpose of executing and concealing the above described scheme and attempting to do so filed and caused to be filed a document, namely schedules and a statement of financial affairs in the proceeding Title 11, namely a Chapter 7 bankruptcy case in violation of Title 18 U.S. Code Section 157.2. And then, of course, it's just signed and all that good stuff. So I'm going to change the title. For those of you that came in late, this is not the alleged boyfriend, so I will change the title. My apologies for the misinformation. My apologies. These names, child, I got this man's name mixed up with the other guy. Both of their names starts with a K. My bad. I apologize. I'm going to get it straight. No, this ain't the Whitehead lawsuit, child. No, but it sounds close. It sounds close to Whitehead. This is out of the Village of Dalton. This is the Super Mayor Tiffany Henyard. Y'all, I mean, this is special kind of dumb. This is a special, like, again, either you were that desperate or you were that dumb. But this is a special kind of stupid. You really thought that by changing where the money went. Now, I'm going to be honest with y'all. I could see if Tiffany hooked him up, right? I could see if Tiffany was like, look, we're going to take you off the books. We're going to start paying you in cash. But you clearly were still on the payroll because you were getting your paycheck, i.e., you're getting a paycheck, meaning it's coming off of payroll, meaning people pay taxes. You were getting your paycheck deposited into the account via direct deposit. Again, I could see if he said, you know, my girl Tiffany, she going to hook me up. She going to fire me on paper, but she's still going to pay me under the table. You know, cash transactions take a little bit longer. They still would have found it. Let's be clear. They still would have found it. But it take a little bit longer. But you really thought that by changing your bank account, your routing, where the paycheck went, you really, truly thought that was going to fool the feds? You really thought that was going to fool the feds. Like, I don't know what's dumber. The fact that you really thought this was going to fool the feds. Like, Sir, you are holding, it sounds like 4 different jobs. You on the board for your wife's business. You own your own LLC. You own government staffing, and you on the payroll for the township of Dalton and the township of Thornton. And you stole money from the township of Robbins, allegedly. You a special kind of dumb. You are a special kind of dumb. Anyway, y'all, that is your Tiffany Henyard update. Again, for those who came in late, the grand jury did convene on yesterday. They asked for a lot of financial documents. Don't expect anything back immediately. They got to go through those documents and all of that. But please understand. That the government was asking for very specific documentation, which tells me that they already know what they need. They just trying to put the cross all their T's and dot all their I's. Princess, who lives in that area, said they still do a lot of stuff literally by paper in those towns. I believe it, but again, they doing it. They got enough to have direct deposit. You know what I'm saying? And if it's being directly deposited off of payroll, eventually you had to know that the FBI was going to come. The IRS was like, you had to know eventually they was going to catch up with you, sir. It's coming off of payroll. You know they pay payroll taxes. Let me tell you something. True story. That happened to me one time. Long story short, this was years ago. I did some consulting work over the summer. I got a 1099. Baby, I filed my taxes because, look, I used to be one of those people that as soon as I got my W-2, I filed my damn taxes. So I filed my damn taxes. I got the 1099. I filed my taxes like mid-January. I got the 1099 by the end of January. Had already filed my daggone taxes. Now, back then, I didn't have somebody doing my taxes like I do now. If I had known then what I know now, of course, I would have done an amendment. Baby, I didn't. I was like, oh, shoot, because it wasn't for that much money. Like, in my mind, I was like, oh, it's not that much money. Mind you, y'all, I was like in my 20s, maybe 30s. Maybe I was in my 30s. I don't think I was in my 20s. I was in my 30s, right? I didn't know then. I ain't know no better. But it was in my mind, I was like, oh, it's not that much money. It's not a big deal. Baby, I got that bill from the IRS. A couple of months later, they was like, oh, yeah, you forgot to include this amount of money. And so this is what you owe us. And most of it was freaking penalties. I was so mad. Again, it was a costly mistake. If I knew then what I know now, I'd have called my tax preparer immediately and been like, look, I got this 1099. I have forgotten about it. I need you to file an amendment. And it would have been a whole lot cheaper for me to file an amendment and whatever adjustment I needed to make. Then, oh, thank you, Jay, for thinking I was still in my 30s. Thank you, boo. But again, if the IRS came after me, I think it was, I don't even think it was more than $2,000. I really don't. I don't remember what it was now, but I know it wasn't a lot of money. When I say not a lot of money, I mean relatively speaking, compared to what this dude was trying to do. I think it was like maybe $1,500, $2,000. It was, I did a little consultant work. It wasn't that big of a deal. I didn't think it was that big of a deal. Baby, by the time the IRS recalculated and then added all the penalties, shit. So if they found me and they got me for a measly $2,000, $1,500, so you didn't claim a whole $100,000 job. $100,000 job, sir. You didn't think they was gonna come look for their money. Anyway. So again, I'm going to change the title. My apologies. I'm going to go back to the drawing board and I'm going to do my research on the alleged boyfriend. His name is Keith. So this was Kenneth. His name is Keith. Okay. And if you came in late, this is our Tiffany Henyard update. And we went over the newest Diddy lawsuit. That's at the beginning of the video. If you came in late, the Diddy lawsuit is at the beginning of the video. Okay. I'm going to get off of here. I'm getting ready to relax. As you can see, I was yawning, honey. I'm about to go to bed is what I'm about to do. I'm about to go to bed. But I will see you guys tomorrow. I have some stuff to do tomorrow, but tomorrow I'm gonna come back and do some reviews. I know I owe y'all everything from the weekend. So we're gonna probably do Martha's Vineyard and maybe New Jersey tomorrow. I know I still owe y'all Never Ever Meets. And then we said we're going to get into Bridgerton. Somebody asked earlier about part 5 of the O.J. Simpson documentary. We'll have to get into that this weekend. I haven't even watched part 5 yet. So I'll watch part 5 this week, and then I'll try to get that in this weekend. It is Memorial Day weekend, so maybe I can do that on Monday. I think that was it. All right, you guys. I'm going to talk to y'all later. Thank you for the super chats, Mims and Carol. I appreciate you guys, and I'll see y'all later. Peace.